I actually, to a part, don't even know where to start on this question because there's so much wrong with the advice the taxpayer is being given that we're going to have to break it up into chunks. All right. So the first point that I need to make at this stage is this is giving me a little bit of PTSD a little bit because if you guys didn't know me at that stage, but when this whole expat tax saga started, honestly, the amount of misinformation and disaster out in the public space, as I'm sure you are all aware, was quite horrifying. And given my job, as you can imagine, I had to sift through a whole bunch of rubbish. But what became crystal clear through that whole expat tax process is that the amount of confusion in the marketplace was exponential. And it came from a variety of different sources. It came from A, chances who genuinely were just trying to make a buck of people who'd read something in the news and were now scared, to the fact that you had people who were Reserve Bank and exchange control specialists and who were taking exchange control rules and trying to apply them in the tax space, not realizing that exchange control and income tax are two fundamentally separate pieces of legislation, to tax specialists who were trying to take tax rules and apply them to the Reserve Bank, to people just reading stuff in the news and not realizing that a word like residency, for example, could have the meaning in the dictionary, the meaning assigned to it in a double taxation agreement, the meaning assigned to it in the Income Tax Act, the meaning assigned to it in the Exchange Control Regulations, and then the meaning assigned to it under our Citizenship Act. Each one of those are independent and different. They may sound similar, but only in the ways that, all ice cream is ice cream if it's made with dairy and stuff. But once you actually start looking at it, ice cream made with frozen bananas is not the same as your dairy made, as your Gino Gianelli, as your, even if you look at the different flavors, they're not the same. And that's the problem with this question, is because I can tell you straight up front, just off the advice given, the financial advisor is looking at this from an exchange control point of view and is absolutely fundamentally wrong about the tax. Point one, 5-year rule doesn't exist in tax. That's an exchange control rule. And then it's an exchange control rule, which, to be blunt, is no longer relevant post March 2021. It used to be that if you did a formal change in residency notification to the Reserve Bank under the MP336B process, part of the declaration you signed was, I will not return to South Africa for 5 years. Okay. So the 5 years does have a grounding in law. It's just not tax. It's exchange control. Right. The second reason why this financial advisor is just, to be blunt, wrong is because exchange control, my residency status pre March 2021, was a question of declaration. If you were South African resident and you felt your residency should change, you had to go to the Reserve Bank, knock on their door, and go and say, hi, please can you make me non-resident? That was the MP336B process, which a lot of people colloquially refer to as financial immigration. That term has no legal definition. It's a shorthand for changing your residency with the Reserve Bank, generally. Other people may mean something different with it. Always clarify what someone means with financial immigration, because there's no legal definition. Okay, coming back to that. So under exchange control rules, if I was exchange control resident and I got on a plane and I moved to Uzbekistan, I would stay South African exchange control resident until such time as I went to the Reserve Bank and said, here's my MP336B4. It was a matter of declaration. Income tax, on the other hand, is a matter of legislation. Whether or not I am resident is a fact-based test based on the reality of my situation at the point in time I need to do the test. So in order to determine whether I am tax resident, and I'm sorry, this really does actually upset me on an almost personal level, is he doesn't need to inform SARS as it could get complicated, has no legal basis. It is so wrong from a legal point of view, I actually cannot even defend it. Because your residency status with SARS is not a matter of declaration. It's a matter of legislation. So I'm all sure we're very fundamentally aware that, and I've talked it through before, about the tick buck process on the RAVO one, and that you can go and do your whole exit tax and yada, yada, yada. Okay, that's fine, but that's just an administrative process. It doesn't change my legal status. My legal residency or not is determined by whether I meet the definition of ordinarily resident in the Income Tax Act, or failing which, if the DTA overrides the legislative application and changes my residency status. It's not a choice. I don't get to choose. Okay, that part is slightly incorrect. If the law says I am non-resident, even if it is fiscally inconvenient for me, I am non-resident, whether I like it or not. In the same way, if it's fiscally inconvenient for me to be non-resident and I want to be resident, that's tough tacky. The law is the law. And as of 1 March 2021, my tax residency, which is a question of law, determines my Reserve Bank status. Now, it's entirely possible that this was someone who just very poorly explained the consequences. But what we need to remember is, as of 1 March 2021, if I get on a plane and leave today, and I have no intention of ever coming back, then under the meaning of ordinarily resident, I became non-resident the second I stepped foot on that plane. Even if I only complete my RAVO 1 process in 2025, the day I stepped foot on the plane is the day I became non-resident. Whether I submitted a tax return or not, whether they'd asked me for additional information, doesn't matter. By law, I was non-resident from that date. Now, can SARS make my life inconvenient for me if I don't go and do the declaration processes and make sure my tax returns are compliant? Absolutely. But we need to distinguish making my life awkward versus they have a legal leg to stand on. Because we need to remember here is to go and say that if we go and have a look at the law, again, tax residency is a matter of law, not declaration. So what is our test? There's two parts to it. Part one, how do I become, or when am I resident in South Africa? Ordinarily resident looks at where is home? Where do I return to from my wanderings? Where do I hang my hat? Put differently, where does my dog live? In my case, where does my cat live? But the point is, like, where are your high school photos? Where is your heart in your home of in your heart of hearts? What's the place you refer to as home? That's where you're ordinarily resident. Now, because that's a question, that's a matter of not just oh, I was in country for 183 days, therefore I am resident. Now, again, I can't go into this in too much detail because we've got 100 other questions to go through. But ordinarily resident is not a days test. It's an intent test, and you need to think of it like building a wall. Each fact that demonstrates I either intended to leave or I intend this to be home is a brick in the wall. And you need to be able to build the wall to build the complete picture to say, in balance of probability, I am resident or I'm not. Okay. Interpretation note 3 goes through this in a lot of detail. So please go have a look at that. Right. Physical presence test. Go and have a look at interpretation note 4 for more detail. A lot of people have tried to tell me, well, I didn't spend enough days in South Africa, therefore I cannot be ordinarily resident. That's just not true. I can be out the country for 5 years and still be ordinarily resident here because I'm taking a work visa with every intent to come back. I literally have a 5-year plan because I want to get a degree, for example, and then I'm coming back. I'm still ordinarily resident. The physical presence is if I answer no to the question of ordinarily resident. Then it's there to go and say, you say this is not home, but you're spending on average, half your time here. We're going to pull you in the net. That's what the physical presence test is for, right? So, what are some of the factors that SARS will look at to determine your residency? Now, please bear in mind, as I say, this is part of the big picture. And if you look at it, the facts that SARS looks at is where do you want home to be? Where do you spend the bulk of your time? Where are your gym memberships? Where's your pet? Where's your immediate family? Which clubs are you a member of? Who do you spend your time with? Where are the bulk of your investments? If you really want to leave here, why have you not applied for citizenship somewhere else? Because if you don't have citizenship, you can't stay there permanently. So are you really planning on leaving? But none of those are by themselves enough to push you in or out of residency. They are looked at as part of the overall picture. So please, please, please be very careful with residency, because if I go back to this question, the problem that this particular client has is he's moved, even if he intends to come back to South Africa. So even if this person in the Netherlands is there on a 2-year work visa, and after that they intend to come back, they are still ordinarily resident in South Africa. Okay. But in this one, we need to add an additional layer to the question because the Netherlands is a DTA country. So to answer the question, and yes, so to answer the question, changing your tax residency when you move, yes, that triggers Section 9H because it's triggered when you change your tax residency. So yes, that triggers. In this case, if I'm going over for 2 or 3 years, I still intend to come back. I'm still ordinarily resident. But there's an additional layer to the residency test because, as I said, the Netherlands is a DTA country. And if I become tax resident in both South Africa and the Netherlands, which is absolutely possible, then I go to the DTA to apply the tiebreaker rules. And it's entirely possible that depending on how I class those tiebreaker rules, again, I don't have scope to go through those in detail now, unfortunately, then I will land either as tax resident in South Africa or as tax resident in the Netherlands. Now, let's for argument's sake say that the DTA puts me into the Netherlands pile. So even though I intend to come back after my 5-year contract, and I, under South African law, consider myself still ordinarily resident, the DTA overrides local law. And because the DTA makes me tax resident in the Netherlands only, Section 9H is triggered. And I have to do the non-residency process through the tax return because I changed my tax residency on the day the DTA tiebreaker rules kick in. It's not a choice. Either that, or you need to go and actively manage your affairs that you don't ever break residency. All possible, but a little bit beyond scope of today, unfortunately. Okay. What I've got on the screen is, please note, each DTA is going to be slightly different. This is the template that is in the current OECD DTA model. So it will look very familiar. There might be slight quirks depending on the country that you're dealing with. So please always go and double check your respective country's DTA. And yes, the DTA always overrides local law. Okay. So physical presence by itself doesn't determine residency. You have to be able to demonstrate intent. Right. What does it mean? It means that when your change in residency comes, you tick the RAVA one and you have to do the Section 9H CGT declaration. Right. Next question. Give you a minute just to read that. Okay. We do currently have, and SARS has admitted that there is a practical problem where you, in that year where I changed residency. Under Section 9H, so under law, I actually have 2 years of assessment in that year because my year of assessment starts on the 1st of March and it ends on the day I become non-resident. Let's pick today, so that makes it the 15th of March. So I have a 15-day tax year. Then on the 16th of March, I have a new tax period which starts and runs to the 28th of Feb. Currently, e-filing doesn't allow for it. So SARS kind of does a little bit of a stick its fingers in its ears and requires you to just to do one return, which is not correct. Okay. So in a situation like this, where you have a change in residency and you need to do a correction, the best approach at this stage is actually just to go via tax practitioner appointment, simply because the returns as they should work and the returns that they've got are different. And it's best to actually go and speak to someone and go and say, right, how do you want me to fix this so that e-filing doesn't break?